Good morning, good afternoon, good evening, not much good depending on your location. Please join in the struggle to liberate our people from the contraption. Like and share videos. Nuro luayo, nuro luayo. Nuro luayo, nuro luayo. Ọ dịghị mgbe ike mmadụ ga-akarị ike Chukwu. Ọ dịghị mgbe ike Naịjirịa ga-akarị ike Biafra. Nna nụrụ onye kere ụwa nụrụ luayo. Nna nụrụ Olisa bi n'igwe nụrụ akwa yo. Now the news updates.
Come back once again. Nnamdi Kanu in custody recently provoked over what Justice Omotosho is doing. But I want to place an accolade and an appreciation to Nnamdi Kanu's lawyer, Aloy Ejimako, and the rest of other lawyers, prominent lawyers, standing firm for Nnamdi Kanu. At this course of this particular video, you're going to listen and see exactly the 8 questions ahead of 10th October that Nnamdi Kanu's lawyer have stated that if that no case submission is not approved by Justice Omotosho, then he should answer these particular questions ahead of that 10th October 2025. Sincerely speaking, Nnamdi Kanu's lawyer are doing a marvelous job. At the course of this particular video, you will see and appreciate the lawyers. You will see and appreciate the lawyers. Aloy Ejimako and other prominent lawyers defending Nnamdi Kanu know exactly what they are doing. At this court, they went as far as sending a message. As if that is not enough, they went as far as putting up 8 good clear questions under prima facie case for Nnamdi Kanu to defend that no case submission. Justice Omotosho never saw this coming. They never believed that no matter what the conspiracy beneath this particular case and the conditions given to Nnamdi Kanu, the lawyers will always stand firm. Sincerely speaking, follow me carefully in this particular video. As you could see, let us dive straight to start, to be expatiating on these 8 questions. Indigenous people of Biafra and Nnamdi Kanu's lawyer in conglomeration went as far as stating that these are the reasons why courts should free Nnamdi Kanu and outrightly accept that no case submission, because this man has no case to answer. As you could see, the indigenous people of Biafra had given reasons why the Federal High Court in Abuja should release its leader Nnamdi Kanu without further delay. Remember that when Nnamdi Kanu was visited by Aloy Ejimako in custody, he told Aloy Ejimako that Emapahafo is one of the designated person that will be giving out information. So there is this synergy between the lawyers of Nnamdi Kanu and the indigenous people of Biafra based on dissemination of information. Now, one of the questions they are going to ask and they have put up to Justice Omotosho is, can prima facie case be established in the absence of an investigation report? Let us expatiate what that prima facie case means. The prima facie case is a legal term referring to a case where the evidence presented by the plaintiff or prosecution is sufficient on its face to establish a claim or charge unless refuted or contradicted by the defendant. The term prima facie is a Latin for at first look or on its face, meaning the initial evidence appears strong enough to support a legal conclusion without further proof. Now, if the lawyers of Nnamdi Kanu is stating that Nnamdi Kanu has no case to answer, and this particular prima facie case, it states that Nnamdi Kanu eventually has no case to answer and he should be freed. Now, they started by stating, can prima facie case be established in the absence of an investigation report? This is a question they are putting up. Adding that, as you can see on your screen, adding that an investigation report is a vital foundation in establishing the elements of a charge and linking it to the accused. Now, there are cases the lawyers brought, citing that case of Ikomi versus the states. It said that the Supreme Court held that failure to conduct a proper investigation renders the entire prosecution incurably defective. In this case, no investigation report linking Nnamdi Kanu to the specific allegations such as incitement, terrorism, and treason has been produced. The lack of any forensic trial or investigative analysis is fatal to the charge. Follow me carefully. The second question the lawyers are now putting up: can a prima facie case be established only on the testimony of 5 DSS officers who came as witness in that particular court? Remember that when the testimony is uncollaborated or partisan, in Adele versus the States, 1999, as quoted, the Court of Appeal warned that evidence of security operatives must be approached with caution, especially where the accused is in conflict with the state. It went on further to state, with a case also, the court ruled that the mere repetition of hearsay evidence or intelligence from anonymous sources, remember that the witnesses were blindfolded, cannot constitute proof of any element of an offense. In this case, all the 5 DSS officers and the witnesses who came to court previously are compromised by their institutional bias, and none has provided first-hand knowledge of any offense. This is not evidence, it is a theater. Nnamdi Kanu's lawyers are doing marvelous job. Now the third question they ask, can a prima facie case be said to have been made without a collaborator named in the charge? Justice Omotosho is seeing these questions. He never knew that Nnamdi Kanu's lawyers are prepared. It is clearer that the failure to name or arraign collaborators renders the charge speculative. Look at this particular case quoted here, where the Supreme Court held that criminal liability cannot be stretched into abstraction without establishing joint action or intention. In the present case of Nnamdi Kanu, the prosecution alleges leadership of a proscribed group and makes valiant references to others, yet fails to name or bring any co-defendants. This is legally untenable. Sincerely speaking, they went further to ask the fourth question. For you to understand that Nnamdi Kanu's lawyer know what they are doing, they went further to state, can a prima facie case be established without a victim? It also said, no and not where the offense presupposed harm or threat to a person or property. Look at the case cited here. The court emphasized the necessity of establishing a victim or injured party in crime of violence, incitement or harm. Who was cited on that particular statement they made against Nnamdi Kanu? Who was attacked? Who is the injured party? None has been presented. No complaint has testified. The absence of a named or identified victims renders the allegations empty. It further asks, you could see that it rendered it empty. All the statements you made that Nnamdi Kanu ordered a certain person to buy so person number of persons and he succeeded in buying 20 or thereabout. Where are the set of persons he bought? Where are their body? Where are the persons that made the allegation and state that Nnamdi Kanu incited violence in my area? Look at evidence. None of them were brought in court. It was just a statement and that was heard by the witnesses. Let us go further. They went further to ask another question, the fifth question. Can a prima facie case be established solely on account of IPOB leadership? Look at it. It said absolutely not. May association with an organization, even one proscribed under ex-parte proceedings, does not ipso facto establish criminal liability. Citing this particular case, the court warned against criminalizing men's status of or political identity. Look at it. In furtherance, in Asari Dokubo versus Federal Government as of 2007, the Supreme Court affirmed that the government must prove that the accused, did more than belong to a group. It must prove a criminal act. No such act has been identified in Nnamdi Kanu's case. The charge is based solely on assumed guilty by association, a perception of justice. Look at it. Nnamdi Kanu's lawyers are doing marvelous job, and I appreciate them and thank them, fervently for doing this marvelous job and putting up these questions. They went further to ask the sixth question. Justice Omotosho, can brokers alone establish a prima facie case? That you say that Nnamdi Kanu made a brokers, can it actually, establish a prima facie case? Now, no mere brokers, absence evidence of causation or specific unlawful outcomes cannot form the basics of a criminal charge. Look at the case stated here. The court held that freedom of expression includes criticism of the government unless such speech can be forensically established or linked to violence. Moreover, in the place of brokers, and whether it fails within Nigerian jurisdiction must be proven, especially when international boundaries are involved. The prosecution had failed to identify time, place, or audience affected. Look at it. They failed to bring these evidences. As if that is not enough, they went further to ask the seventh question. Can negative outcome on all the above still lead to a conviction? The answer is no. If all fundamental elements collapse, no conviction is possible. Look at this case quoted here. The court declared that if the prosecution fails to establish a prima facie case, the trial court must discharge the accused. Where there is no victim, no investigator, no co-conspirator, no accused recuse, no jurisdictional link, the law cannot proceed to conviction on air. Sincerely speaking, when you see these questions that is being put up to Justice Omotosho ahead of the rumor that he's not going to accept that no case submission, you will begin to understand and see that Nnamdi Kanu's lawyers are doing a lot of job in conglomeration with the IPOB. Sincerely speaking. The last but not the least, they went further to ask Justice Omotosho for the very last time, can ex parte prescription establish a prima facie case? Can it establish a prima facie case? A prescription order granted ex parte, in quote, without hearing the accused, has no eventual weight in a criminal trial. Look at the case quoted here. The Supreme Court in that particular case insisted that due process cannot be bypassed for expediency. A prosecution obtained without hearing IPOB or Nnamdi Kanu is administrative, not judicial. It cannot substitute for proof of a criminal offense. Moreover, prosecutions itself is under challenge, rendering it judicially unsettled and incompetent as a basis for conviction. The Nigerian government has no case to answer unless Justice Omotosho wishes to join those who have disintegrated Nigerian judiciary. He must answer these questions. This is exactly what they are stating, and he must answer these questions honestly, lawfully, and courageously. Any court that sidesteps these critical issues is no longer a court of justice but a tool of oppression. If the prosecution is relying on no case or no investigation report, only DSS witnesses without first-hand knowledge, no identified victims, no named collaborators, no jurisdiction over the alleged brokers, and a dubious ex parte prosecution, then there is no case to answer. This is not just a legal crisis, this is a moral reckoning, and to all Nigerians, both on the north, the east, and the west, this is a test of how long you will allow injustice to reign under the guise of the law. This is exactly what the lawyers have stated, and it is a clear message to Judge Omotosho to do the needful. On a clear note, if these questions are not answered clearly and lawfully, then the prosecution has failed and the court has no choice but to discharge Nnamdi Kanu. Sincerely speaking, if anyone is doubting the reasons and proof Nnamdi Kanu are actually using winning this particular case, just forward this particular video to that person for the person to be clarified that Nnamdi Kanu's lawyers are doing marvelous job.
My people, on don't hear them now. What do you make of it? Drop your comments. But remember, it's Biafra or nothing. Bye for now.